unanimous decision of the Supreme Court in the impeachment case against Vice President Sara Duterte continues to reap a whirlwind of criticism. A remarkable number of statements from former justices, law professors, and civil society leaders has criticized the decision as judicial overreach. What did the Supreme Court get wrong? And what can be done about it? Hi, I'm John Nery, and you are in the Public Square. One of the most illuminating and also most candid responses to the ruling has been a series of comments from retired Supreme Court Justice Adolf Azcuna, who, among many other distinguished achievements, was also a member of the 1986 Constitutional Commission that wrote the 1987 Constitution. I'm happy to say that he is with us today. Thank you, Justice Azcuna, for joining us in the Public Square.
Thank you, John.
Justice, let me get straight to it. It was a unanimous decision, 13-0. Can the Supreme Court still reverse itself?
Yes, it's still possible, John, for the Supreme Court to revisit its decision and reverse even completely. It's really perhaps not very probable, but it can happen.
Has that happened before, a unanimous en banc decision?
I am not sure it has, but somebody said it has.
Can the Supreme Court call for oral arguments this late in the case?
Yes, the Supreme Court can set the motion for reconsideration for oral arguments to allow the parties to ventilate the different points that are involved in this case.
Do you have any idea why oral arguments were not called for in the first place?
Perhaps the court felt there was a need to decide the case before the lapse of the 19th Congress and then the entrance of the new Congress. So there was that eventuality that I think the court wanted to come out with a decision while the 19th Congress was still alive.
Well, the decision came out on July 25.
Yes.
So the 19th Congress ended on June 30, but the 20th Congress had not yet started its first session, which was on July 28, I think.
That's right.
That's right. What can the Supreme Court do now that the House of Representatives has filed a motion for reconsideration, as represented by their counsel, the Solicitor General? What can the Supreme Court do? I know it has already asked Vice President Duterte to comment within 10 days.
Yes.
What are the options open to the Supreme Court now?
First is the oral arguments to set the motion for reconsideration for oral arguments.
Okay.
And that would be the best, I think, option open to the Supreme Court, since it did not set the main case for oral arguments. And then to perhaps invite amici curiae, other than the parties, to help the court in the reaching a fair outcome to this motion for reconsideration.
Can it call for a status quo ante? Can it decide that? Is that one of the options?
Yes, it can also, in the meantime, call upon all the parties through a resolution calling for a status quo ante to maintain the status quo so as not to render the matter moot and academic and to allow the Supreme Court to revisit its decision after full oral arguments from all the parties involved. The danger is the Senate might preempt the whole thing by dismissing the articles even before the Supreme Court can hear the motion for reconsideration.
So what will happen if the Senate decides to adjourn as an impeachment court or dismiss the articles, as you said?
First of all, John, I think the Senate cannot do that because you will remember that the Senate returned the articles to the House, and it is now still awaiting for the House, the new 20th Congress, House of Representatives, to send back the articles to the Senate and to state, as requested, that it is ready and willing to prosecute the same. So in my view, the Senate cannot now dismiss the articles because it doesn't have the articles before it. It's with the House.
But the Senate is eminently a political institution.
Yes.
What if more than enough senator judges
Yes.
decide to, well, the Supreme Court, it should be immediately executory, so we will execute immediately.
Yes, assuming that it can execute it immediately, that is to dismiss the case, if not the articles. There are two things that will happen. It can render the case moot and academic, or it can allow the Supreme Court to still proceed because of two things. One is it can issue a status quo ante resolution. And a status quo ante not only maintains the status quo, but can order the restoration of the previous status quo before the action was taken to dismiss the articles. So that still would keep the case alive, even if the Senate would dismiss the articles. The second is what is known as the doctrine of still in case of cases that are moot and academic, there is a doctrine that the court can still decide the issue because the issue is of utmost importance and it is capable of repetition and escaping review. That doctrine, capable of repetition and escaping review, will allow the court to proceed and decide the issue, even if it is moot and academic.
Justice, if the Senate will not yet decide to adjourn or to dismiss the articles, what would a status quo ante resolution from the Supreme Court mean? This will bring us back to before July 25 or when the Senate remanded the articles of impeachment? What would be the status quo before?
It would be the situation at the time the Supreme Court rendered its decision.
Okay.
And that is the Senate had adjourned and had returned the articles to the House and is awaiting the House to send it back to them. So that would be in short that the option of the Senate there would be to wait rather than to act.
Justice, you are, of course, a founding father of the post-EDSA constitutional order. You were part of the 1986 Constitutional Commission. How much weight does the Supreme Court give to CONCOM deliberations?
The usual rule there, John, is that deliberations are not very heavy in the determination of the intent of the Constitution. And what is the number one rule is the plain meaning rule. You just follow the plain meaning as judged from the language of the Constitution. The deliberations are not an accurate guide because of the rule that it only expresses what the person talking is meaning, but those who are keeping quiet do not necessarily agree with what is being said. And so it may be a guide, but not a very reliable guide to the intent. They would rather pursue the plain meaning of the language itself.
And yet the Supreme Court has, in many instances, referred to CONCOM deliberations, I guess, to shed light on intent and so on. And of course, you, speaking as a framer of this Constitution, to the ordinary layman, to the ordinary citizen, your word carries a lot of weight.
Yes.
The Supreme Court doesn't see it that way, or that's not the way you construe
They find it helpful, but not controlling. So they look for other sources of the intent. Also because they say it's the people's intent that really counts, not those of the framers. And when they approve the Constitution, they may have different interpretations of what they're approving.
Okay.
So the safest, according to the court in previous rulings, is to follow the language itself, the plain meaning of the provision. And then only when there is doubt should resort to deliberations.
I found something really fascinating in the pleading of the Solicitor General in the motion for reconsideration when it went over the history of the one-third provision, Article 11, Section 3, 4, which allows the House of Representatives to immediately pass on the articles of impeachment if at least one-third of the membership has voted. And I found this fascinating because it did not only refer to the points of view raised during the deliberations, but it actually highlighted the vote. There was a motion to bring it back to the 1/5 under the 1973 Constitution, which for some reason Marcos, had inserted into the Constitution. So there was a vote between should it be the much more lenient 1/5 or the, I think Commissioner Mambong called it the happy compromise of 1/3. So for me, as an ordinary person reading that part, I mean, this is not just a point of view of one or two framers. There was a vote, I think 24-14, no? Panalo yung 1/3, which, there's am I right to see that as more important than just the point of view raised by a commissioner? The actual vote.
Yes. Actually, we had a choice. We had the 1935 Constitution, which made it very hard, 2/3, in order to approve an impeachment complaint. And the 1973 Constitution, which was silent on the voting and left it to legislation. And the legislation at that time made it easier, 1/5. So you had a choice between 2/3 and 1/5. And we chose the middle ground, not too hard, not too easy, and that is a 1/3. So if you follow the historical background, it's really a choice of the middle ground, not very easy, not very hard.
Justice, a couple more questions about procedure and so on, because a lot of people are asking these questions, I would think, before we move on to the substantive arguments that you've made. We understand that the...
Sorry.
That's all right. That justices or judges apply facts and the law, right, to reach a decision. How can the Supreme Court correct itself if it had misappreciated a key fact? I am, of course, referring here to the contention in the ruling by Justice Marvic Leonen that the archiving of the 3 complaints had happened before more than 1/3 of the members of the House decided to impeach Vice President Duterte. How can the Supreme Court correct itself? It got a key fact wrong.
Well, it simply makes a resolution deciding the motion for reconsideration in which it can correct its previous ruling or amend the decision if it is a far-reaching change. It can correct its mistake, and it has done so before. It is not above correcting itself, and that is the purpose for an oral argument. So if there's anything that can be improved or corrected, I think the court is willing to do so.
Okay. Will the same ponente also write the decision ruling on the motion for consideration? Or is it possible that there will be a reassignment of roles, perhaps? How does that work?
That's a very good question, John. Usually, the ponente remains the same unless the decision is reversed and there's a dissenting opinion, and the dissenting opinion wins during a revoting, in which case the main dissenter will be the ponente. But unless that happens, if the same majority supports with modification the decision, it will be the same ponente.
Do you need a dissenting opinion? Is it possible that, because here it's 13-0, there, as far as I can tell, there were no other separate concurring or dissenting opinions. Is it possible that during the deliberations, somebody will argue, a path forward, and then there will be more justices favoring that new path? So that person who that justice who suggested that new path would be the one to write the decision, the new decision, if ever? Does it work that way?
If the present ponente is outvoted, he can no longer speak for the majority. Ponente speaks for the majority.
Okay.
So if there's a new majority and the present ponente is not part of that, there will be a new ponente.
I see. Maybe one last question about procedure. You are Chancellor Emeritus of the Philippine Judicial Academy, right? So you train judges and so on under the aegis of the Supreme Court. This decision in Duterte versus House of Representatives, that sort of, what's the word? It unsettles a lot of already settled doctrine that justices and judges have followed since at least 2003, Francisco versus... how would it affect, what you teach judges or new appellate justices and so on?
Yeah, well, to start with, judges are used to changing doctrines.
Okay.
While there is the rule of stare decisis that prevails, it is not written in stone, and the court is free to depart from previous jurisprudence as new developments come in. So judges are used to that. As long as it is arrived at fairly, with proper hearing and consultation, it is usually accepted by the judges. They are used to changing doctrines.
Justice, let's move on to the more substantive part, the arguments that you've raised. The very first comment that you released, you characterized the retrospective application of the new set of rules about initiation as, unfair.
Yes.
Can you walk us through that?
Yes, I said that the decision, even if maybe it's legally correct, is to me rather unfair, because it would apply to a situation, a new rule, a new finding or a new doctrine, which was not available at the time the action in question was taken. And the action in question was taken in conformity with the very rule that the Supreme Court itself promulgated in a previous case. So you cannot blame the House for following the previous prevailing rule, and it would be unfair to apply on that action a new rule, which could not have been known by the actor at the time the act was done. This is known as the doctrine of operative facts. You cannot apply retroactively a new doctrine. It would be unfair. However, it has been pointed out that this doctrine applies only when the actor acted in good faith. I can say two things there. One, there is no finding that the House acted in bad faith. There can be none because there was no hearing. In order to find bad faith, you must have hearing, evidence submitted, because bad faith is not presumed. So we have to presume that the House acted in good faith. Number two, even assuming the House acted in bad faith, it's not the only actor here. The main actor here is the people themselves. And the people are in good faith. They are expecting accountability. And the principle, after all, is that public officials are accountable to the people at all times. At all, that's the rule. So the exception of not more than one complaint every year is an exception. And exceptions must be strictly construed so as not to destroy the rule. And that is what is, in my view, happening here. The exception is being applied with a doctrine retroactively applied that will destroy the main rule, which is accountability. As applied now, the accountability principle will be very difficult to enforce.
I can't help but notice that in your first comment, you said that even if this is the legally justified, you cannot retroactively apply it. That would be unfair. I think in your second comment you already said no, but actually the new rules overstep. They bind the House and the Senate. And so maybe you're suggesting that it's not legally justified. My question is, over the last several days, your view or views on the ruling have evolved? Have they?
The decision says it has not really overturned the previous ruling. It has merely modified it to apply it to an unusual situation, which is a situation where the three complaints could no longer be referred to a proper committee as required by the Constitution because it was deliberately delayed in being calendared. So that is the special situation, and they crafted a rule for that special situation. So if at all justified in applying it to the present case, I think the other doctrine should apply, which is to apply it only to this case, because the situation is so unusual. Don't make a general rule out of it. Don't govern future cases that are not attended with the same deliberate move to avoid a hearing to it. That is called the pro hac vice approach. You find the situation so unusual, so you say this decision applies only for this particular case. In the future, we will listen to the new situation and apply a different rule.
But then for that principle to take effect, the court should have held oral arguments to determine, right? Not to presume bad faith and
yes,
right?
Oral arguments will help the court in determining whether or not it is justifiable to adopt that rule of pro hac vice here because of the very unusual situation that is involved in this case. Namely that the impeachment is caught between the passage and the lapse of one Congress and the entry of another. That is very unusual. The other is the adoption of a fourth complaint in the face of three previous complaints, but which were not initiated under the old doctrine. So this is very unusual. And according to the rule of Justice Holmes, when you have a hard and difficult case, you make a general law out of it, that becomes a bad law. They said hard cases make bad law. So you should not make a general rule out of very unusual factual situations.
In your second comment, you made this very illuminating distinction about due process. So for ordinary people, due process simply means, your day in court, right? Fairness. But in fact, the constitutional provision has three antecedents. It refers to possible deprivation of life, liberty, and property. And you said none of these are at stake in the impeachment of any impeachable official. Actually, this is the one that really went viral. People were sharing this and, oo nga, no? People were saying, oo nga, no? We just assumed due process meant this. but it actually has these three antecedents. Again, can you walk us through your thinking, Justice?
Yes, it struck me really that the decision would apply the requirements of due process in all stages of impeachment. This would involve applying it in the early stages and not in the trial stage where it should really be, because normally trial involves hearing the other side. But in the initial stages, to require due process, I think is not proper, it's not correct. Because to start with, the due process strictly applies only when it involves deprivation, or possible deprivation of life, liberty, and property, which admittedly is not involved in an impeachment case. Secondly, the court cites a 7-point procedure of procedural due process that would apply it to the second mode of impeachment. And I noticed that the source of this 7-point rule, which is acknowledged by the decision, is Antibai versus Court of Industrial Relations. And that case involved property rights. It involved the contractual rights of laborers. And that's property. A right under contract under the Civil Code is property. So in Antibai, the respondents stood to be deprived of property rights. That's why due process was required. Procedural due process was crafted by the Supreme Court there to apply to cases against laborers who stand to be deprived of their rights to their contract. Not to apply it here where no property rights are involved.
Yeah. So it's very important, right? You said public office is a public trust. So a government office is not property, right? The official doesn't own it.
It's not.
But I'm wondering whether this decision, Duterte versus House of Representatives, is expanding the meaning of property to now include reputation. There are a couple of passages there that refer to, the damage has been done to the reputation. Is it possible to consider the reputation of a public official as, in fact, property?
That would be an amending the concept of property under the Civil Code. Reputation and honor are intangibles which are not considered property in the strict sense of the term. I think that would be, again, a new doctrine that should not be applied retroactively.
Okay.
Yes.
All right. So another of your arguments was that this ruling has actually overstepped on the constituent powers of the Senate and the House. I'm not sure if the majority of senators today see that as an affront to the Senate as an institution, but I think we're seeing a majority of congressmen saying, wait a minute, that's our role. No? Can any of these chambers force a constitutional crisis to force the Supreme Court to decide in a different way? For instance, not increase the budget. You're not allowed to decrease the budget of the Judiciary, but you can freeze it at the current level, until they change. Is that something that a chamber can do?
To start with, John, I don't recommend a confrontation among our branches of government, because that would destroy our legal system and our fragile democracy. I hope that in the present crisis, our institutions will find a way to reconcile their differences so that our democracy will survive. The Congress, of course, can, to me, adopt the following. They have the rule-making power. Under the Constitution, the Congress, the House, and the Senate is given the power and the mandate to adopt rules to carry out these procedures for accountability under Article 11. And so I believe that even with the pronouncements of the Supreme Court, they can amend that by adopting a different rule. Before, the rules of court was amendable by Congress.
Okay.
We removed that. Under the present Constitution, we put the sole power to adopt rules of court, Supreme Court. Congress can no longer amend the rules of court. But the rules of procedure for enforcing the accountability is given precisely to Congress, not to the court. So if the court, in this case, in the guise of interpretation, intervenes and adopts rules, those rules themselves can be amended by Congress. So Congress can correct whatever it regards as an error by adopting a different rule in the future. And then on the budget, sad to say, John, really, Congress at present has already put a cap. It says we cannot increase your budget, so we cannot decrease your budget, so we will not increase it. So that was our mistake in the Constitutional Commission, because we thought, okay, prohibit them from decreasing it. So Congress said, okay, we will not increase it. In terms of actual magnitude, they increase it. But in terms of percentage, it has been fixed to not more than 2%. So sometimes only 1% of the entire budget for the entire Supreme Court and the Judiciary, less than 1%. So to me, that should be corrected also. The courts are unable to function. What the Supreme Court does is not to organize all the courts. We have unorganized courts. We lack courts, but we are only functioning 70% because the 30% intended for these new courts is used as savings to fund the 70%, which otherwise would lack the budget. So that doesn't have to be retaliation. It's already there.
Oh, wow.
Yes.
I did not realize that. So maybe they could turn it into an incentive instead.
Yeah.
Justice, in your argument related to constituent powers, you offered also this line that judges cannot be, the justices cannot be judges in their own case. No? So they are themselves, by constitutional definition, impeachable officials. So themselves, they have themselves added new impeachment rules, which apply to them. And you said that shouldn't be the case.
Yes.
Can you please explain?
I said that the rules regarding impeachment was placed by the Constitution precisely in Congress because Congress is not impeachable. You cannot impeach them. And so when they craft the rules, they don't craft it for themselves because they are not impeachable. So if the Supreme Court, which was not given the power to craft these rules, is still under the guise of due process, craft these rules, that to me would be violative of the cornerstone of due process, which is that no person can be the judge in his or her own case. And in this case, they cannot define the rules for their own possible impeachment. That would violate the heart of due process. And yet they're doing it in this decision. So what is wrong with that? It defies the very idea of due process, that you cannot craft the rules that will judge yourself, especially where these rules were already explicitly lodged with another department.
What is the difference between Duterte versus House of Representatives and outlining these new rules, and let's say the 2003 Francisco ruling, which defined initiation as consisting of endorsement and then handing it to the Committee on Justice. The difference there is those are found in the Constitution.
Yes, in the Francisco case, John, they merely interpreted the word initiate. They did not impose a new rule. They just said what initiate means is calendared and referred to a committee. but they did not impose due process rules, which includes notice and hearing in the plenary in the second mode. That would be usurping, I think, the exclusive power of the House to initiate and to govern by rules all cases of impeachment. So this is no longer interpretation. But fortunately, John, I believe that these are obiter dicta. They are not binding precedents. These portions of the decision that include pronouncements of due process requirements, 7-point due process rules. These are obiter. They are not part of the ruling because they are not necessary to decide the case. They have already said that this articles is invalid because it is against the one-year rule. So if it's against the one-year rule, it's invalid. You cannot go into other pronouncements. If it were valid, it would be against due process. It's not valid in the first place. So there's no room to apply due process to an invalid, non-existing article. So obiter. An obiter po ay parang advisory lang yan for future, but not binding. So I'm not really worried with that because even if it's not obiter, it can be amended. But if it's obiter, it doesn't have to be followed.
Overall, Justice, you see this. In fact, you did say this, no? That the principal casualty is the principle of accountability. You even, if I'm not mistaken, use the word, it's almost impossible now to hold an impeachable official to account. Wouldn't that have occurred to the Supreme Court justices? I mean, what do you think were they thinking? Why did they unanimously agree on this ruling?
I think there is something that they could not say, which is that the House acted in bad faith. They couldn't say that because they have no evidence. There is a concurring opinion that says that, but the evidence is the Secretary General stating something during an interview with Karen Davila. And technically, that's not admissible evidence. So wala silang solid evidence to say the House acted in bad faith. And yet they are applying a decision, a ruling, that is really based on bad faith on the part of the House. So that is the problem. And so I think in that case, there should be oral arguments so that they can go more deeply into the actual facts, what really happened. And then also, secondly, to allow the court to delineate up to what point can they themselves frame rules to govern impeachment. The other thing is, that's why I said it's almost impossible already, this accountability. You see, the rule now is you cannot file a criminal case against a high public official unless you first file impeachment. That's the rule of the Supreme Court.
Okay.
So if there's a pending impeachment case, the ombudsman cannot file a criminal case. If there is no pending impeachment case, it is required to file first an impeachment case before resorting to criminal case. Now, if the impeachment case is almost impossible to be filed, therefore even the criminal cases cannot be filed. So there's no more accountability, not only through impeachment, but even through criminal cases. Because impeachment is a sine qua non first priority before resort to criminal and civil cases. But impeachment is already made very hard, almost impossible. So where does the accountability lie? Wala na.
Surely this could not be by design, right? I mean, this is an unintended consequence.
Unintended
of the
this
ruling.
Is perhaps the reason why it should be revisited. Yes.
This has been really illuminating. I have a few more questions, but that's the time we have. Justice and Constitutional Commissioner Adolf Azcuna, thank you very much.
Thank you, John.
And that's it for us today. The next step for engaged citizens, as always, is to take a more active part in the democratic project. Please download the Rappler Communities app and join the chat room of your choice. And if you haven't yet, join Rappler Plus. Thank you. This is John Nery. See you in the public square.